Okay, today we're going to be talking about corporations again, and we'll be talking about directors and officers. Directors are usually nominated by the management, and they're elected by the shareholders. They establish corporate policies. They hire, fire, and supervise the corporate officers who make most of the day-to-day decisions. Directors actually just supervise them in some ways, make sure that they're following the correct strategy and that they're doing the right things. But the directors will not be stepping in and giving any orders to anybody except for the officers. They can only order the officers. That's what they'll do. And so the directors are responsible for establishing corporate policies. And so they establish compensation of the management. That's including the officers and themselves. They propose major decisions, for example, whether or not to merge, whether or not to consolidations, major acquisitions, etc. Although some of these actually would require a shareholder vote, as we'll see in later lectures. Usually subject to a vote of shareholders. These mergers and consolidations and acquisitions are. Okay. Directors and officers and owners. Sometimes actions that benefit the corporation as an entity do not benefit the managers of the corporation. Indeed, the managers may be benefited at the expense of the shareholders. This is often called the agency problem. To understand it, we examine the rights and duties of these managers and the owners. Board members, board meetings, regular meetings. They are established by the bylaws or by board resolution, so they can schedule a special meeting if they want to. So they would do that by a board resolution. And so these special meetings would be just established to deal with an urgent matter, and therefore, whenever they're meeting, they have to have, of course, a quorum requirement. Certain people have to have like a majority. Usually set by the article. What the quorum requirement is usually set by the bylaws. If set by statute, which is a possibility, the state could set it, but nowadays I think very few states would do that. It is usually a majority of the number of authorized directors. Rights of directors. The directors have a right to participate and inspect the records. Anything that was discussed. They have a right to look at any of the papers. They have a right to demand from the officers access to the files, whether it's accounting files or whether it's sales files or whatever it is, employment files. They have a right to look into those, and they have a right to participate in the meeting itself. They have a right, of course, to notice of any special meetings that are being called. Compensation and indemnification. In large publicly traded corporation, compensation is usually substantial, often set by the directors themselves. So directors set their own pay, if you would. And oftentimes it may include stock options. And stock options were seen as a way of motivating directors to do that which was in the best interest of the shareholders. Some people, though, say what they seem to have done is just used it as a means to greatly increase their incomes, and therefore maybe it's not such directly tied to what the shareholders' interest is. Removal of directors. In the majority of states, except it can only be done, the directors can only be removed by the shareholders for cause, and obviously they can also be removed at annual meetings. Rare exception may be removed for under a reserved right. So there may be something in the Articles of Incorporation that gives the right to remove the directors, maybe by the other directors. So there may be a reserved right. Some articles, bylaws, or statutes will give the board itself power to remove a director subject to shareholder approval. So that's more common, rather than them being able to just get rid of somebody. They can get rid of somebody by vote, who they think is not acting in the best interest of the corporation. but it would be subject to, usually the power to remove would be subject to shareholder approval, so they'd have to, put it before the shareholders for a vote. Of course, shareholders vote by the number of shares they have. Subcommittees. Numerous subcommittees of the board are established in large publicly traded companies to deal with important matters. So there's always an audit committee, subcommittee. Under Sarbanes-Oxley, there needs to be a Sarbanes subcommittee, and even before that, it was generally true that we almost always had nothing more important than measuring how much income to shareholders. How much income is the company making? Is it making a profit or not? So you want to have an audit subcommittee to make sure that the audit is being conducted right. And so you're not leaving it just to the officers to hire some accountants to come in and audit them. Also there's usually a compensation subcommittee. Recommends the compensation of directors and officers. So the directors sit on these subcommittees. So some directors decide for the rest of the directors how compensation will be determined, and maybe even who gets what. So there's compensation subcommittee. Director's term of office, usually 1 year, and thus may be removed by majority vote once a year. Staggered terms limit the number of directors voted on at the annual meetings. Thus, directors often serve for 3 or more years. This makes it harder for shareholders to change the management of the corporation. In effect, it insulates the officers from shareholder control. So a very popular scheme. Some corporations are organized by the promoters, by the incorporators. They're organized, and there'll be, let's say they're going to elect 9 officers there's going to be 9 directors, okay? And the first 3 directors will be elected to 1 year. And then another group of electors will be elected to 2 years. And then the third group of directors will be elected for 3 years. And after that, every time there's a need to fill these vacancies, it's a 3-year term. And so you wind up with a staggered term. And in any 1 year, you can only remove 3 directors. So the majority of the directors remain on the board, and therefore the shareholders can't make a radical change in the management of the corporation if you have that kind of structure in your corporation. So that would all be set out in the Articles of Incorporation. Duties of officers and directors. Although directors are not agents, they and officers both have duties of care and loyalty as fiduciaries. So they have fiduciary duty is to act in good faith. So they have to act in good faith for the corporation. Directors can be held liable for failure to inform themselves or failure to exercise reasonable supervision. So a lawsuit might allege that the decisions of the board were very sloppy, and they didn't really know what they were doing, and that's because they didn't actually maybe hear testimony from the managers and the officers. So the officers would be needing to be called to the directors' meeting and maybe testify as to what was being done in the collection of information and the decisions that were made. And so the directors, they're supervisors basically, so they need to do that. And if there's a proposed merger, they're going to have to do some research, and they're going to have to inform themselves on the advantages and disadvantages of being, merged. Or if some firm wants to acquire them, they have to maybe have meetings on that, and then they'll make recommendations to the shareholders as to whether or not the shareholders, and we'll see this later when we talk about how corporations are funded in the SEC. So basically the directors will make recommendations on how these shareholders should vote when there's a proposed merger, because they have to actually sell their shares for the merger to happen. So that's that. So directors can be held liable. So in a sense, the shareholders, if you look at it that way, have ultimate control. But in a matter of fact, a lot of the shareholders do not really actively pay much attention to their shares, stocks. They widely diversify, and they don't own enough in any one company to spend a lot of time looking just at that company when they got all their other money invested in other companies. So they're not going to be looking at any company, maybe management and how it's doing, or doing a lot of critical thinking, unless something really pops up where, you know, some major issue comes up. They're not likely to pay much attention. The directors, the officers and directors are presumed to be shareholders are presumed to approve board actions even when they are not present. Okay. A director who's supposed to come to a meeting, if he's not present, he'll be deemed to have approved what the other directors do. So he maybe become liable that way if the other directors are making their decisions without being informed, and if it's a bad decision. Duty of care. So they have a duty of care as fiduciaries to make, and what is this duty? To make reasonably informed and reasonable decisions, to exercise reasonable supervision. Note, they can be held liable for irresponsible votes. So if they make their votes in good faith, and if they inform themselves and they deliberate and hear the issues and you know, adequately document what they've done to make sure on the issues before them, then they don't have a problem. We can assert what's called the business judgment rule, which we'll talk about later. Duty of loyalty. They have a duty not to compete with the corporation. So basically, if you're working for, say, an automobile company, you would then not be able to open up your own automobile company, or you know, join a group that's starting a new corporate, because that'd be competing with the corporation. So you couldn't do that. You can't compete with it. If you're in a professional corporation, of course, you need to stay with your corporation. If you're going to resign, that's another issue. But as long as you're working with and for the corporation, you have to be loyal. They have to avoid conflicts of interest. So, you know, these might come up. And, you know, if they're working, say, in the oil industry, and they take a position with another oil company as an officer or director with that other oil company, then there's an issue of conflict of interest. So they have to avoid those kinds of conflicts of interest. There can be no usurping of corporate opportunities. This oftentimes might happen with smaller corporations that maybe they're organized. Corporations have perpetual life, but in fact, they can be set up to expire after a certain time. So let's say you decided to start a corporation, and it was to run a shopping mall, and you set it up for 25 years. After 25 years, you have to make a decision whether you want to continue it. You can continue with it, and you know, renew it, so to speak, set up another set of years for it to be operating, or you could close it down and take whatever profits you made, sell off the shopping mall, or you know, sell off whatever assets you have. You could do that, but what would you do now if you had an opportunity to make a certain monies, a lot of money, you know, by getting into some other field, or there's an opportunity that the directors know about but you don't know about, and so some directors, they don't tell you about this opportunity. They themselves arrange for them to get the opportunity. So they're going to enter with some other group and become part owner of the mall, and maybe retain their positions in the mall at the same time. And so they're acting in conflict of interest with you, because they should be advising you on the advisability of taking this opportunity. And if they do so and you don't take it, they can obviously go in and do it. Also, sometimes if you're in a corporation where there's some buying of property, if the corporation buys property, let's say that the corporation buys antiques and resells them. Okay. And one of the directors knows of some antique to buy and doesn't tell them. That's violating his duty of loyalty. He instead buys it himself and then sells it maybe even to the corporation itself. He's doing a number of things he shouldn't be doing, right? self-dealing, so to speak. Okay, so no engaging in illegal insider trading. Illegal insider trading is if you know that there's something going to happen in the future with the corporation. Let's say that the corporation found a gold mine. Well, the gold mine means that the corporation is going to have an opportunity to make a lot more money. Once that's announced to the stock market, the stock's going to go up. And so you're a director, you know about this. It's not been released to the public, so they don't know it yet. And before it's released to the public, you yourself buy more shares in the corporation in order to benefit yourself. That's a breach of the duty of loyalty. Okay, you can't be engaging in illegal insider trading. That's what insider trading is. It's buying when you know there's something going to happen. It could also be something. I talked about positive kind of things. It could also be something negative, where you know there's a lawsuit that's going to be filed or has been filed, but it hasn't been announced yet, or that the corporation which makes drugs is going to have fail in its attempt to get approval of a certain drug that it was counting on to increase its profits. That would be a negative kind of thing. And if you then sell your stock, that would be insider trading. If you're Sharon Watkins and you have reason to believe that the corporation will implode and you sell your stocks, you're engaging in insider trading. She did that, but the prosecutors have discretion, and they didn't prosecute her because she was seen as somebody who was really responsible for the disclosure of the wrongdoings at Enron was ultimately her doing, even though she didn't really intend it that way. So I always have to laugh when I think about that one. No selling of corporate control. So some company wants to take over, and he comes to you privately, and he tells you, well, you're a director now, but if you help me, gain corporate control, give me information, and if you help me in my attempt to gain corporate control, I will make you the chairman of the board. Okay, that's breach of duty of loyalty then, right? So you're selling the corporate control, you're selling out the corporation. Loyalty of a corporate entity, or you could actually go and hire somebody to buy it for you. I guess you could. And so if that also might come in with the usurping of corporate opportunities, right? Loyalty to corporate entity requires that they not authorize transactions detrimental to minority shareholders. So they represent all the shareholders, and therefore they cannot favor majority for and sacrifice and impair maybe the interests of the minority. They have to represent everybody. Business judgment rule. I told you we'd get to this. Anyway, this rule insulates directors from tort liability for a corporate decision as long as the decision was within the power of the corporation. That is, it's not ultra vires. And if the director, so last time we talked about ultra vires, I believe, if the director in good faith made an informed, reasonable, and loyal decision. All those words are important. It has to be an informed, it has to be reasonable, and it has to be a loyal decision. So they also have to have, it also has to be within the power of the corporation, and he has to be in good faith. What would be an absence of good faith? Maybe some evidence of some wrongdoing of some sort. Requirement of the business judgment rule. Officers and directors must act in good faith, the best interest of the entity, with care and of a reasonably prudent person. So this is kind of breaking down some of these requirements. After reasonably informing themselves with a rational basis for their decision, avoiding conflicts of interest, directors must avoid being a rubber stamp. So if the chairman of the if the CEO or anybody wants to, basically for them to do something and push it forward to, and some companies, the CEO is not only CEO, he's also chairman of the board, and he's a very powerful figure, and therefore, that's a situation that might lead to what we would call a lot of yes men, right? And so we would call that being a rubber stamp. And sometimes also we call it just being potted plants that are sitting there not doing anything. They're just going along with whatever the so-called boss wants to do. So that's requirements of the business judgment rule. Shareholders' rights. We don't have shareholder democracy, yet shareholders have some power. They can elect and remove directors at the annual meetings, okay? And they can vote on resolutions. So there's some major decisions, might have a resolution attached to it. and they get to vote on those. They have a right when there's fundamental corporate changes, those kind of things have to be put before the shareholders so they can vote on it. Although often these are subject to prior board approval, so the board has to approve. Let's say that they decided that the best thing to do, it's in the best interest of everybody to go into bankruptcy. It's a major corporate decision. Or they decide to merge with they decide on a merger with another firm. That's a major corporate decision. Or they're going to restructure the debt. That's going to be a major corporate decision. So they're going to go to the bank and get more money because they want to expand the business. They want to get into some. So far they've been an automobile company, but now they're going to be getting into airplanes too. They're going to have an airline or something's going to start an air service. So that would be a major fundamental change in the business. So those are the kind of things. Those are definitely things that the shareholders would have to vote on. They bought shares in an automobile company, not those other kinds of businesses, and therefore that might have been a conscious decision as to how they want to risk their money. So they might not want to risk associated with these other industries. Proxy control. The management of the corporation can perpetuate itself, can keep itself in business by soliciting proxies from shareholders. Proxies that are then voted by the current management. So the shareholder issues a proxy, gives it to the management, and the management then can vote it any way it wants to. What do you think they're going to do with it? They're going to vote for themselves. And so if they solicit proxies, and there's a lot of people who buy shares that don't really pay attention and aren't really interested in voting because they say, well, I don't know anything about it. I bought these shares. I got other shares over here, and so they're highly diversified, and they're not taking a particular interest in this corporation, and so they don't really know anything about it. And say, well, I can't vote, but they may still feel, well, my vote should be counted anyway, and so I'll give a proxy to the management. Of course, I presume that they would only do that if they were happy with what the management had been doing. And of course, with Enron, the shareholders were very happy with what they thought Enron had been doing, which was making money, but they didn't know that actually Enron was just falsifying books. So I'm sure they otherwise wouldn't approve. And I'm sure there was a lot of proxies that Enron got to vote for itself. The Enron managers got to vote to keep themselves in power. Street control. Brokerage firms can gain power within a corporation by voting shares held in street names. So some people who buy shares don't want their name on the share. Could be all kinds of reasons why they don't want their name on the share. Difficult for others to know that they have this interest, maybe, I don't know. So this gives the brokerage firms some influence with the management of publicly traded companies. So the brokerage firm could go to them and say, now, we think you ought to be doing this, and we'll be voting our shares. So they'll have influence. Maybe they may have a lot of shares that they can vote from a lot of people who didn't want their name on the shares. Shareholders in a closed corporation usually are more involved in the corporation and more informed. Closed corporations are small corporations, usually within a group, whose shares are not traded on an exchange. You cannot go and buy shares in that corporation. You have to buy it from somebody who's already owning those shares. And there may be restrictions on him for selling to you. So you can't go to a shareholder and say, hey, I want to buy your shares. It's not that easy. He's got to offer those shares usually to the other shareholders so that they can buy it, usually in proportion, so that they maintain their relative proportion ownership of the thing. So they have a right of what we call a right of first refusal on the shares. So if they all refuse or someone refuse, that person can buy those shares that they've refused. So usually they're more involved, or oftentimes even sitting as directors or officers. So they know more about what's going on. They're going to be keeping a very close tab, unlike somebody who buys a few shares in a very large corporation, and he's got shares in all kinds of other corporations. He's not going to be too much involved. So they participate at shareholders' meetings, so they take an active interest. Often are employed as managers or otherwise by the corporation. May agree to a voting trust or agreement as to how the shares will be voted. So they may agree to vote their shares all together in order to maintain some sort of balance. Often they have a right of preemption or right of first refusal. So I talked about that. Right of preemption is the right to, and the right of first refusal is the right to buy the shares. Voting trust and agreements. So, trust, basically if they establish a voting trust, then legal title is transferred to a trustee who votes all of the shares. So you would have to agree to that, okay? So you find somebody that all the shareholders maybe can trust, or a majority of the shareholders trust, and you create a voting trust, and he's going to vote all of those shares. And he should be doing it in accordance with the wishes of the shareholders, obviously, who created the trust. They receive a voting trust certificate and receive the dividends. So that person who's trustee is not going to get the dividends. You'll be getting the dividends, but you won't have to be as involved in the corporation. Or you can be certain that there's not going to be a breakup of the group. So it's one thing to say, oh, me, Tom, Phil, and George are all friends, and so we can control this board, we can control this corporation because there's only seven directors, and we can vote in 4 of the directors because we are 4, and the other shareholders all owning equal shares, they can only elect 3. And so we'll all agree to vote our shares together, and that way there's none of us can change our mind and switch over to the other side. So it's a way of locking people in. Of course, you're only locked in for what you've agreed to, so you might want to put a period of years in there. Agreements, voting agreements, a valid and enforceable agreement amongst shareholders to vote in a specified manner may involve true proxy. So you can do it either as a trust or an agreement. Trust is usually more permanent, whereas an agreement might be just one election. Transfer of shares. In a closed corporation, the transfer of stock is usually restricted by bylaws. So these bylaws, that's where you'll find the right of first refusal, the right to preemption, and maybe some other things that restrict people in selling or dealing with their shares. The right of first refusal is a restriction that gives to the corporation for a reasonable time, the corporate owners for a reasonable time, a priority right to buy at a reasonable rate any shareholder stock if the shareholder decides to sell. So the corporation itself will be able to buy those shares, and therefore everybody maintains their shares. It doesn't necessarily have to then buy other people's shares. Shareholders' rights to dissolve. Directors are deadlocked. Okay, so what can that happen? Well, yeah, if you have an even number of directors, say you got 4 directors or 2 directors or 8 directors, if they split up evenly, you can get into a deadlock situation where nothing can be done. And maybe you can't issue the kind of dividends you would like to. The Management Directors Act are illegal, oppressive, or fraudulent. If there's some indication that some directors are doing something in fraud, you can have that investigated, but you'd like to maybe settle that in a board meeting somehow. Assets are misapplied. So, you can for these things, directors are deadlocked, or the management has been acting illegally, oppressively, or fraudulently, or the assets are being misapplied or wasted. In other words, property is being lost because they're not taking care of things. Shareholders are deadlocked for a specified period. So it depends upon how it's written. It could be just that they're deadlocked. That might give you a right then to seek a dissolution. Or it might have to be a certain number of years, a certain number of annual meetings. So two annual meetings deadlocked, then you have a right to dissolve the corporation. 3, maybe you have a right then to dissolve the corporation. Anything beyond that, it would seem rather ridiculous to be in deadlock situation and not do something about it. But so I don't think we'll see anything where it goes beyond 3 years. Shareholders' derivative suits. These are suits brought by a shareholder, a suit brought against the corporation by a shareholder to enforce rights of the entity and or to recover damages for the entity. So basically the idea there is that the directors and the officers are not doing what they should in pursuing rights that the corporation have, and is maybe not trying to collect damages from people who should be paying them damages for negligence. Maybe some employee, or maybe it's one of the officers, or maybe one of the directors has injured the corporation, and you feel like he should be sued, and he should be paying this money to the corporation, he should be paying damages. Well, you as a shareholder can bring that suit. These often are brought against directors and officers who have violated their fiduciary duty. So are they acting in bad faith? Yeah, that's not easy to prove maybe. Liability of shareholders. Generally they have no liability, except, and so these are exceptions, majority shareholders may be liable if by controlling the directors they cause a violation of fiduciary duty owed to a minority shareholders or the entity. So are they interfering with the corporation in a way that damages the minority shareholders because they're using their power as the majority shareholder? This could even be brought against a group that has controlling interest. Anyway, controlling interest is enough votes to win the elections. That is to have a majority on the directors, majority of directors who you put in there. Anyway, water stock. If less than fair market value was paid, so there is a shareholder who basically maybe gave something, but it was overvalued. So let's say he contributed a building, and he got credit for $1 million on that building, but it turns out the building was only worth $200,000. Okay, so he was overpaid for it. That's watered stock. So he got stock for that building, and he got those stocks, and it became a shareholder. And so you can also get stock for by services. If you were in creating a corporation, if you were the lawyer who handled all of the documents and prepared all the documents, you would charge a fee for that, or you could take stock for that. Okay, well, how much you take would be a matter of agreement, but it could come up. The issue is how much is this worth. So you have to look at what other people would have been getting if they'd done it. So anyway, water stock. So that would be a shareholder who would be liable because he obtained something he shouldn't have obtained, usually by some sort of shenanigans, right?